Hello, my name is Bob Rust. I'm with Rust Law, LLC. Along with myself are attorneys Alicia Mealy and attorney Pamela Zetterberg and our paralegal Kathy Highland. We're a small firm, but we are quick and we're lean and we're competitive. And our areas of focus are estate work, which includes wills, trusts, powers of attorney and the like, estate administration, assisting an executor administer an estate after the death of a loved one, business law, which ranges from formation of businesses, startups, to advising owners of privately held mature businesses, to land use law, where there is a need to get a municipal ruling on the particular use of land. Those are areas of focus. Included in that will be a lot of real estate right across from it. One of the things that comes up quite frequently, and it crosses over both in terms of a family's need for sound estate documents and wills, powers of attorney, but a business owner's need for a sound business plan. Where is it most appropriate just to go with a will, and where is it appropriate to consider the use of a trust? Well, please remember that a will speaks only to those assets that the individual owns entirely, to his or herself, and there's no other claim of ownership. What do I mean by that? Well, if you have a joint tenancy in a residence with your wife or husband, that is not solely owned by you. Upon your death, that asset will pass by operational law to your spouse. If you've got a life insurance policy, an annuity, a 401k plan, that asset will pass by contract, whoever you've designated as your beneficiary. So one of the things you need to first look at is, what do I have that is truly just mine? If it's a business, that's a big deal. Because if you're the prime or the majority owner, then for sure, a will is going to be very important in terms of what powers you give your executor to deal with your business interest during the time that the estate is administered. But if you're concerned about going into the future because there are concerns for children, for grandchildren, even great-grandchildren, or for that matter, even concerns for employees, a will is only as good as passing the asset to another party, and that party, once he or she has it, is free to do with it whatever he or she may want to do. Whereby a trust, an asset put in trust, the trustee must do with that asset, manage it, administer it in the way that the terms of the trust dictate. So it can be held for generations, for example, if that's the desire. It can be held with specific business provisions, if that's the desire. The trustee is to select someone to come in and manage the business that the decedent had formerly managed. A trust, in other words, will live on by virtue of its terms and conditions, and it will terminate according to its terms and conditions. And I might say that there are many types of trust, and I do not have the time at the moment to go into the different types, but I would encourage you to look into that with your attorney if you are interested, because a trust indeed is a flexible and an excellent tool to protect as well as enhance the interest of your loved ones, of those that you care about, and including your employees. And if you'd like to talk with us further about it, I encourage you to contact us, care of 610-821-0484, 610-821-0484. Kathy Highland will answer the phone, and she will immediately put you in touch either with myself or attorneys Amelie and Zetterberg. Thank you very much.